Welcome back. So just a moment, we're going to be joined by Chieftain of the ADC as we explore the issue even further as far as the conversation around deregistration of political parties is concerned. So if you're not familiar with the conversation, let me just do a quick 1 minute or less rundown or explain. Yesterday, Justice Peter Lifo of the Federal High Court had given an order saying that the parties that did not meet up to what they call the presidential threshold or the presidential election threshold, according to Section 225 of the Constitution, should be deregistered by INEC. It's a constitutional requirement. So it's a ground norm. It's not an act of parliament. It's a ground norm. So that's but the argument is to the fact that there was already a stay of action or execution of proceedings issued by the Court of Appeal for that proceedings to hold on pending maybe an interlocutory appeal filed by the accord party. How the legalese will play out is different kettle of fish. But let me read for you what the law says. So if my producer can hold this. The registration of political party, the Independent National Electoral Commission shall have the power to register a political party for, 1, breach of any of its requirements for registration. If we go to the next one, which is a controversial one, not controversial, which is the basis for this judgment, I should have said. 1, failure to win at least 25% of votes cast in one state of the federation in a presidential election. So the lawyers are saying that when an election is conducted, if you fielded a presidential candidate in the 36 states and the FCT, when we do the computation, your party should be able to have at least 25% of vote in at least one of those 36 states and the FCT, perhaps, to be able to say they can still field presidential candidates in the next election, or is a premise. Whether or not this is going to be the premise to register party is another kettle of fish. One local government of the state in a governorship election, if we go to the next one, because I just want to read through all the conditions. Failure to win at least 1 ward in a chairmanship election, 1 seat in a national or state House of Assembly election, or 1 seat in a councillorship election. So these are some of the... So the argument now is, this is the argument which we try to get from the Leonard Silk. He answered the best way he can, and we're also going to talk to somebody who is also a lawyer, in fact, the former Attorney General of his state, on what this provision means. So what is the big question? Is it that all 3 conditions must be met for deregistration? What I mean by all conditions mean the condition for how you can, the victory poll, the victory tally for presidential, governorship, chairmanship, National Assembly, or councillorship. Is it that if you don't fulfill all of this 5, then you can be deregistered? Or if you fail in fulfilling just 1, you can be deregistered? That is what the lawyer, lawyers will have to look for a way to ingeniously look at this thing. So let's bring in our guest. Alex Adum is an ADC chieftain and a former Attorney General of Benue State. Mr. Adum, thank you for coming on the program. If you can hear me and help us unmute your device, Mr. Adum, we really appreciate it. Can you hear us now? Mr. Adum? Oh, dear. Apparently, because we're trying to get Mr. Adum to come into the conversation. I'm happy he's also a lawyer, so he brings his perspective. So my question again is, there are 3 sets or 5 sets of elections that were listed by the Constitution. Yeah. The presidential, the governorship, the chairmanship, National Assembly, and I think councillorship. Yeah. So is it that, my question will be, is it that if, for instance, you couldn't meet up in the presidential, but you met up in any of the others, including councillorship, you should still be an existing political party? I did ask the senior advocate, what was his response? I didn't pick question. He said, it doesn't exclude you from the process, that the requirement of this constitution is for political parties to show up and, after registration, comply with the constitution and not just go to sleep. And that's why, again, I asked him at the, as we close that segment, what this means for political parties, and especially for political parties that go to sleep after elections have been fought and won by the
the winner decided in the polls. They must, continue engagement for visibility and for trust and to build the democratic structure such that the people can scrutinize them, have enough time to scrutinize them, and then make up their minds whether they qualify for their votes in the next election cycle.
So is it a question, looking at that law now, I'm just processing it, because this is the same thing that happened with this 25% in the FCT, remember, whether it's conjunctive or disjunctive. Do you understand? So whether it is together or not together. So is it that the entire 5 will have to happen for a party to be deregistered, because the lawyers may be divided on that, or one? And remember, the 25% says even if you win the entire country, if you don't win Abuja in the presidential election, the argument before that election was you cannot be declared president. But if the Supreme
whether
Court,
it's and or the Abuja matter,
conjunctive and disjunctive, the Supreme Court said no. It doesn't work like that. For now, we are clear. Supreme Court says you don't have to win the FCT, because there's no special status of the FCT that should say even if you win the 36 states, if you don't win FCT, you shouldn't be declared president.
And
so
it's an interesting part of the conversation.
Let's see.
By the way, I went to check the ADC's presidential election result in 2023. Dumebi Kachiku was a presidential candidate, and I think he scored a little above 8,000.
80,000.
8,000 votes.
Is it 80 or 80,000? You have to check.
Yes.
But let's see what we have here. Let's bring in our guest, Mr. Adam. Thank you. Are you there now? Let's be sure we can hear you and you can hear us.
Yeah, I can hear you, Geoffrey. Good morning, Nigeria.
All right, fantastic. Before we go to all the issues, I'm looking at the results of your last election. So let's begin with your first order. The party has written to say the APC government is playing with fire. So that's a very strong word. But I'll stay with you as a lawyer and also as a party man. First, let's talk about the provision according to law. Is that the word now, conjunctive now, to say all of the five elections that are listed is the only premise to say if you cannot fulfill presidential, governorship, National Assembly, chairmanship, and councillorship, all of these conditions, then you can be deregistered. Or if you cannot fulfill, even maybe you fulfill 4 and you don't fulfill, let me not confuse myself. So if for instance, the presidential election, for instance, that if you don't fulfill it, that should be a premise, even if you got other elections right. Is that what the law says, or what's your interpretation?
No. Good morning, Charles. Thank you very much for this opportunity to speak on this matter. Indeed, I listened very attentively to my learned senior advocate, your previous guest on set, and I was a bit amused as to why he was prevaricating as to what exactly the position of the law is. There is no ambiguity in the provisions of Section 225A of the 1999 Constitution. That particular provision amended the 2017 round of amendments, to ensure that the independent provision has the powers to register for political parties who don't perform at a certain minimum threshold. And that minimum threshold lists about 5 different criteria, starting from winning at least 25% in the presidential election, or winning a seat in the National Assembly, or in the State Assembly, or in councillorship election. So or in English, it's not ambiguous, or it's disjunctive. So the conditions are provided under Section 225A as disjunctive, conditions. Once you meet one, that suffices. And it is important to point out here that the powers that are vested under Section 225A are vested in INEC. There are judicial powers vested in INEC to make a determination that this religion has not performed up to this certain threshold. And I said the threshold as mentioned, but 1 to 5 of those conditions are disjunctive conditions.
Oh dear. Ms. Adam, my sincere apologies. We really want to hear your take on this matter, but I don't know what's going on with your network. I hope that we can sort this out. as soon as possible, because I wanted you to weigh in on whether the provision of 225A of the Constitution is either conjunctive or disjunctive in this sense. So for non-lawyers, what I'm simply asking is to say whether you have to fulfill all criteria before you can continue in an election. If you don't fulfill all of it together at in one election cycle, or however that election cycle works, that it captures all of it, you may not be able to field candidates. Or if you fulfill even one, let's even say it's councillorship election, if you fulfill that, you should still be on the ballot. So that's the conjunctive and disjunctive. Let's see whether we can get Mr. Adams' legal interpretation. Then we can talk about the politics therein, because I'm looking at numbers here. Mr. Adam, are you there now? Let's just try. Let's hear you out and see whether... just go ahead. Let's see whether we can work. We can hear you, but it's breaking. That's the problem.
Oh, sorry.
Yes.
Okay. My point is that provisions of Section 225A are disjunctive. They are conjunctive conditions. So the requirement is for you to meet one out of the 5 conditions stipulated in Section 225A. And so once you meet one of the conditions, you are obliged to remain a registered party in Nigeria. And so the take is that no court has the powers to direct INEC to do its work. If INEC itself has said, for instance, in the case of the ADC, INEC's deposition import was the extent that the ADC has met all the requirements, for registration as a political party. Mind you that the ADC won 2 House of Representatives in Kogi State in the 2023 round of general elections. And we also won about 7 House of Assemblies in the same round of elections. Indeed, the former minority leader of the Benue House of Assembly, Honorable Cephas Diako, who represents Kogi State constituency, was a member of the ADC and won that election on the platform of the ADC. So it is an irony for you to say that ADC is registered because it did not meet the constitutional requirements. So these conditions are disjunctive, they are not conjunctive.
And I believe the senior advocate did speak to that effect about it being disjunctive, not conjunctive. I wonder what you mean by saying that he was prevaricating. He did say that you didn't have to fulfill all of the items in Section 225 of the Constitution as provided. But you're saying that no court has the powers to compel INEC to do its work. But in the case of that Court of Appeal order, in the case between your party and Nafi Balagombe, the Court of Appeal did order INEC to maintain status quo ante bellum in the leadership dispute. And INEC, based on its own interpretation of what status quo ante bellum meant, complied with that court order. I'm wondering how you're weighing in on this, in relation to the prior development.
Okay. My take is that, that is the more reason why the Supreme Court has consistently held that, political matters are some of these internal political matters are non-justiciable. They're non-justiciable because the moment the courts dabble into political disputes, you are going to have conflicting judgments of the court. So ordinarily, when this matter came up before the Federal High Court, one of the preliminary objections that was raised that the court overruled, that required the court party to go on appeal, was the fact that the court lacks jurisdiction to entertain this matter, because it's a matter that is non-justiciable. And because the parties who are instituting this particular litigation against the 5 political parties are parties who don't have local standard. And they don't have local standard because they have no direct personal injury, incur no direct personal injury because of the existence of the 5 political parties. And because they have no direct personal injury, they have no cause of action before the court. Because if you have no injury, there can be no remedy. Why do you provide the remedy where there is no injury? So I am saying that the court should not dabble into matters that are purely political. These are matters that are relating to the capacity of INEC. The powers that are vested in Section 225A are administrative powers, not judicial powers. These powers are vested in INEC to examine, based on the conduct of its own elections, and the elections conducted by state independent electoral commissions, which also work in conjunction with INEC. Because when you say they win even a councillorship election, INEC does not conduct councillorship elections. So they can only relate with state independent electoral commissions to determine whether a party has won even a councillorship election. So it is not for the court to determine that INEC go and deregister this particular political party because they have not met the requirements. No, it is for INEC to determine. And INEC has determined that the party that you're seeking to deregister, the ADC for instance, has met all the requirements. That is evident in the materials that are before the court. So I am wondering why Justice Lifu did not pay attention to the counter affidavit filed by INEC, the evidence provided by INEC, the evidence provided by the political parties themselves, that they have won elections, they have met with the criteria, they have met with the conditions. For instance, one of the conditions is that you must have at least offices in 2/3 states of the Federation and the FCT. Can you say that any of these political parties that is registered today does not have political offices in Abuja and in 2/3 states of the Federation? So once they have met the criteria, it is preposterous for the court, to say, go and deregister them. Go and deregister on what basis?
Okay, so Mr. Adum, just before the ship sails on the matter of conjunctive and disjunctive, perhaps it's the, the highfalutin nature of the words that are confusing. Disjunctive meaning separate and or. Conjunctive meaning that they are together, right?
Combination of all, yes.
All those items in Section 225A of the Constitution, the requirement to win a state, the requirement to win councillorship, National Assembly, help us understand where the ADC stands as far as those items are concerned.
Okay. Now, like I said before, the ADC won 2 House of Representatives seats in the 2023 general election. Honorable Leke Abejide, that just decamped from the ADC to the APC, was a member of the ADC until 2026. The ADC won 7 House of Assembly seats across the Federation. So in terms of meeting the requirements, the ADC met those particular electoral threshold conditions stipulated in the Constitution. The ADC also has a national headquarters and has party offices in all the 36 states of the Federation, functional chapters of the ADC, and party offices presence in 36 states of the Federation and the FCT. The ADC has also won some councillorship elections, which I cannot even remember now, because, mind you, the ADC was registered as far back as 2006. So in terms of meeting the requirements for existing as a political party, the ADC is on solid ground. Now, even if you say Honorable Leke Abejide has decamped from the ADC to the APC, look at how many people have also decamped into the ADC. Because it is not about when people decampment, because if decampment is going to affect the constitutional requirement, then decamping from another party should also apply. So on all fours, ADC is on solid ground with respect to Section 225A. We have not breached it. We are not operating in negation of Section 225A. So it is, I don't find it legally. There is no basis to deregister the ADC today on the basis of not meeting the requirements of Section 225A. And in any case, the Constitution should not be interpreted so narrowly. There are several other provisions in the Constitution that ensure, for instance, the freedom of association, which is enshrined under Section 40, which is a fundamental human right of any Nigerian. And then Section 14, which talks about plurality of the democratic process in Nigeria. And you have also Section 221 up to 229, which ensures that every Nigerian has a right to belong to a political party of his choice. So when you narrowly construe Section 225A in violation of Section 14, Section 40, Section 221, and up to Section 229, you are not interpreting the Constitution of the Federal Republic of Nigeria. So it's a very narrow construction. So I don't see how you can say that the ADC has not met the requirements to exist as a political party.
All right, so Ms. Adam, as we're going to wind down, so if we agree that this is disjunctive, I wonder what exactly is the premise for which the judge made the decision? Because I know for a fact that at least Honorable Leke Abejide is one on the ADC platform back-to-back. And so I also know from the data I have available, you may correct me, ADC scored about 81,000 votes, which is less than 1% in the last election. In fact, in all of the states, he scored less than 1% in all of the states. So what do you think was presented to the judge if it is disjunctive and we have a clear record to show that at least at the National Assembly there was a member at the polls before all the defections happened back and forth that won an election? What was the premise?
There is no premise. This is just politics. Even the condition of 25%, like you mentioned, the requirement is not strictly for the presidential election. The requirement is for every election in every constituency that the party participates in. So if the party participated in a councillorship election, the requirement is that the party must win up to 25%. If they don't win a seat at all, they must win up to 25% of the votes cast in that particular constituency, which is the councillorship election. You can move to a state house of assembly constituency, you can move to a federal constituency, you can move to a senatorial constituency, a gubernatorial constituency, and then the national, which is the presidential election. So the requirement is not that the party must win 25% in the presidential election. Section 225A is couched in very straight, plain language. There is no ambiguity at all. So you have asked me the same question I'm asking myself. Having not seen the CTC of that judgment, I am asking myself and I'm wondering, on what basis did Justice Lifu base his conclusion and judgment that the ADC has not met the requirements to exist as a political party? And mind you, there is a stay of execution, stay of proceedings issued by the Court of Appeal on the 22nd of May in respect of this particular matter, directing the lower court to stay all action pending the determination of the appeal before the Court of Appeal. All right. Which appeal is to be heard on the 27th of October. So if there is a pending stay of proceedings issued by an appellate court, can a lower court still proceed to go to judgment? I have never heard in all my 27 years of practice, I have never seen this kind of thing before. All right. If this is not pure politics, I'm going back to June 12th type of Justice Payment kind of midnight judgment. I don't see what this represents.
Ms. Adam, the good thing about jurisprudence is the fact that there's a sequence. So there's a trial court, there's the appellate court, there's the Supreme Court. And in fact, some people will argue to the effect that the trial court is even allowed to make mistakes that can be corrected in the higher court. So let's see how INEC and your party...
Make an obvious mistake when you don't make an obvious mistake in the face of a directive from a superior court that you should not proceed. This is contempt of court.
Well, I leave that to you lawyers and politicians. My job is to mainstream the conversation and let's make sense out of it. And we all learn from the situation. But I must thank you, Mr. Adam. Alex Adam is an ADC chieftain and a former Attorney General of Benue State. Thank you, sir. We appreciate it.
Thank you very much.
Now we'll take a break, and when we come back after this break, we'll leave the Nigerian conversation for a bit. One of ours is making us proud in Faro, United States, in the state of California. We're going to have a conversation with him because of what he oversees in that state. And let's do some peer review and what we can learn from each other. That will be in a moment. Stay with us.